In the previous lesson, what we did was introduce the concept of parliamentary sovereignty. This lesson, I want to essentially talk about the history of this principle and explain how it develops out of the period of the Stuart dynasty within Britain, and then talk about how modern conceptualizations of the principle exists to this day. So, like I said, the previous lesson introduced the subject of parliamentary sovereignty, we outlined its meaning, and then also we outlined a number of the implications that exist therein. So, for example, the concept of parliamentary sovereignty being both a positive and negative set of obligations on the part of the fact that Parliament, from a positive sense, can make and unmake any law they so choose, but they also have this fact that we have a negative element of sovereignty, which suggests that other institutions and organizations have to always regard parliamentary legislation and they can never disregard and ever set it aside. This lesson, like I've said, is going to explore the historical development of this principle and examine how it applies to this day. Now, beginning first then with the early history of the principle. In the earliest of history of England, we see that the concept of parliamentary sovereignty, or at least the concept of sovereignty, where power lies, was something which was exercised by the sovereign, him or herself, this being the authority of the royal council, and that this is really where we see the authority of lawmaking beginning in the history of England. The council, the royal council, or the cura regis, would develop into the creation of the first parliaments, and that these first parliaments would lead to the establishment of a formal legislature throughout time. The understanding of how Parliament is structured today, in fact, comes out of what is known as the Model Parliament in 1295 under Edward I. This was where we see, firstly, the division of Parliament into two branches. So you have the idea of bicameralism actually beginning in 1295 under Edward I. You have bishops, abbots, and barons forming the House of Lords, and then you have two knights from each shire forming the House of Commons. This is the model parliament of 1295. In 1539, Parliament passes the Statute of Proclamations. So we see a significant period of time where we see Parliament essentially being subordinate to that of the Crown, being called by the Crown to pass legislation, often for financial purposes. 1539 is a year where the monarch in England was Henry VIII. Henry VIII would rule England from 1509 to 1547, and in 1539 Parliament passes the Statute of Proclamations. This gave the king at the time, as I mentioned, Henry VIII, the broad powers and the broader authority to essentially legislate without reference or consent from Parliament. One of the historical traditions that existed with monarchies even before Henry VIII was this idea that you would call Parliament to legislate, and you would require the consent of Parliament to legislate. In fact, this was one of the most significant influences that Henry VII attributed to his consolidation of authority and royal authority. His claim to the throne was very, very weak in comparison, and so to end the Wars of the Roses in 1485, what Henry VII did was call Parliament to ensure his royal authority. Okay. And so ultimately, this is a tradition that becomes a little bit skewered with his son Henry VIII, because in 1539 we see the passage of the Statute of Proclamations, differing, like I said, from his father Henry VII, who believed and regarded the requirement that Parliament be required for the passage of legislation. In 1610, then, when we see a transfer in dynasties away from the Stuart period with the death of Elizabeth I in 1603, and we see James I becoming the first Stuart monarch, we see the case of the Dr. Bonham's case. In this case, the Lord Justice Coke would ultimately establish the rule which seemed to contradict any idea of parliamentary sovereignty. So remember, this is before parliamentary sovereignty becomes an established and enshrined principle. Because in this case, what Coke essentially does is suggest that the common law is sovereign, and it is Parliament that is subordinate to the common law. Coke noted that the common law may be able to control the power of Parliament, and even declare provisions were void if they were against common right and reason, or repugnant or impossible to be performed. What this is doing is essentially enshrining the idea that it is the rule of law which is the authoritative principle of the UK Constitution, or at least the British Constitution, and that this idea of parliamentary sovereignty is subordinate to the rule of law, owing to the fact that the rule of law essentially allows for parliamentary decisions or parliamentary legislation to be set aside if it is repugnant or impossible to be performed. The ultimate conclusion that we see here is that the English Civil War changes all of these processes quite significantly. This is one of the most fundamental power struggles that existed, and really it was a question of where we see power lie. The supporters of Charles I, the Royalists, argued that that sovereignty laid in the hands of the king, and that sovereignty was delegated by the king with the express permission of the king to Parliament. The Parliamentarians, the people who supported Parliament, as you can probably imagine, believed that sovereignty lied with Parliament, acting on behalf of the people. Ultimately, this is what the English Civil War was about the fact that Charles I would continually try to raise taxation and try to raise finances from Parliament, and that then would ultimately cause a lot of division and disputes between the two sides, between the Royalists and the Parliamentarians. Again, the main issue was where the power of taxation lied. Charles I would often exert his right to issue new taxes, and would do so without the consent of Parliament, shall I say. Even though the remit of Parliament and the fact that taxation was a provision and a competence made by Parliament was something that had been established all the way back in the 1200s with the reign of Edward I. Without divulging into too much detail about the English Civil War, the regicide of Charles I, and the back and forth and the restoration of the monarchy, we see that we get the restoration of the monarchy, but then we get a new monarch who is invited in, because James II, who is ultimately replaced by William of Orange, we see this with the 1688 Glorious Revolution. Okay, so when the reign of James II, who was a Roman Catholic, would come to clash with that of Parliament, we see that Parliament decides, very prominent politicians would actually sign a letter inviting the son-in-law of James II, who was William of Orange, who was a Protestant, to come and take the throne. And so William of Orange would do so, and was met with very little resistance, and a convention parliament was called in regard to this particular invitation. Ultimately, his invitation to reign came with a number of conditions, one of which was an acceptance of the 1689 Bill of Rights. And the significance of this was the fact that essentially what it asserted was that the rights it asserted the rights of Parliament over the monarch and his wife Mary II. And ultimately, we see in 1689, the Earl of Shaftesbury state that the Parliament of England is the supreme and absolute power, which gives life and motion to the English government. And this essentially is enshrining, in 1689, the year of the Bill of Rights, the year after the Glorious Revolution, a fundamental shift in where Parliament lies in the broader structure of authority. Parliament lies at the top. Parliament is sovereign as a result of these events that take place. So this is really where the history of parliamentary sovereignty ultimately begins to take shape and becomes the most prominent principle of the UK Constitution. In the next lesson, we'll sort of do a little jump to the more modern conceptions of parliamentary sovereignty and talk about some of the principles of parliamentary sovereignty.